Namaskaram. Hello everyone. Welcome to Arthashastra Learning Center Polity Current Affairs. I am Ramu, a student of Arthashastra Learning Center. I think you may all know about the movie 24. Today I would like to discuss one of the interesting topic, the story of 24 in Indian polity. That is nothing but the basic structure doctrine given by the Supreme Court in Keshava and Bharati case of 1973. It's not evolved in a single case, it is gradually evolved in different cases. To understand the evolution of the basic structure doctrine, we need to understand these two clashes between the articles. Then this the first clash is Article verse 13 versus Article 368, and the second clash is Article 19 class 1 class F and Article 31 versus Article 39 class B and Article 39 class C. Let's see these clashes. Article 13 says if any law is inconsistent with fundamental rights shall be declared as void and unconstitutional by the judiciary, whereas Article 36 gives complete authority to the parliament to amend any part of the constitution including the fundamental rights. There is a clash between these. In on this clash, Article 19 class 1 class F and Article 31 gives right to property to the citizens under fundamental rights, whereas Article 39 class B and Article 39 class C in the DPSP gives directions to the state for the equal distribution of wealth and resources. To give effect to these articles in DPSP and for the land reforms, the government, the legislature has anticipated these problems and they came up with the first Constitutional Amendment Act of 1951 and they inserted 31 capital A and Article 31 capital B and Schedule 9. Article 31 capital A says if the land acquired for the land reforms is not against the fundamental rights of right to property given to the citizens, and these laws should be keep in Schedule 9, and Article 31 capital B gives blanket protection to the Schedule 9 against the judicial review. This first Constitutional Amendment Act was challenged in the Shankari Prasad versus Union of India 1951 case, and the Supreme Court said yes, the Parliament has absolute authority to amend any part of the Constitution, including the fundamental rights, and the term law given in the Article 13 is only by the Constitutional Amendment Act, but not the ordinary law. Meaning, the Parliament can take away or make changes to the fundamental rights only by Constitutional Amendment Act, but not by ordinary law. And if they did by Constitutional Amendment Act, it will not come under the judicial review. And in the Sajjan Singh case versus State of Punjab in 1965, the Supreme Court was upheld its previous judgment and said, yes, you have absolute or complete authority to amend the Constitution, including the fundamental rights. And the term law in Article 13 says includes both Constitutional Amendment Act and ordinary law, meaning they can amend the fundamental rights by ordinary law, and it will not come under the judicial review. See the next in the Golaknath versus State of Punjab in 1967, the Supreme Court given up totally opposite judgment. It's overruled the previous judgment. We call it as a prospective overruling, and the Supreme Court said the Article 368 gives only the procedure but not the power to the Parliament to amend the Constitution. The Parliament has no right to amend the fundamental rights. How can you amend? These are the basic rights given to the citizens of the country. To counter this major impact, the legislature has come up with the three Constitutional Amendment Act, the 24th, 25th, and 29th Constitutional Amendment Acts. The 24th Constitutional Amendment Act added the word power to Article 368. It made the Parliament have both power and procedure to amend the Constitution. And the 25th Constitutional Amendment Act said any legislations made to give effect to Article 39 in the DPSP, it's not against the fundamental rights. It's not violating Article 14, 19, and 31, it said. And Constitution and the 29th Constitutional Amendment Act added some of the Kerala Land Reforms Act of Kerala in the Schedule 9. These three Constitutional Amendment Act was challenged in the Keshava and the Bharati case of State of Kerala in 1973. And this was a landmark judgment. It is the highest number of judges heard case, that is 30 number of judges was given their verdict, landmark judgment, and the Supreme Court said, the Parliament has complete authority, but it's not absolute, it's limited power. It should not touch or affect the basic features in the Constitution. But the Supreme Court didn't define the basic structure in this case. It is given in the next coming cases. Let's see, in Indira Gandhi versus Raj Narayan case of 1975, the Supreme Court said the democracy, judicial review, the federalism, and rule of law is the part of the basic structure. In Minerva Mills case versus Union of India in 1980, the Supreme Court said the harmony between the fundamental rights and the DPSP are one of the basic structure of the Constitution, and they are complementary to each other. In S.R. Bommai versus Union of India case 1994, the Supreme Court said the federalism, democracy, and secularism is also part of basic structure. In Chandrakumar versus Union of India case 1987, say judicial review is the part of basic structure. In IR Kuyolo versus State of Tamil Nadu case 2007, it said it upheld that judicial review is the part of basic structure and said any legislatures which made part of the 9th schedule after 24th April 1973 also come under judicial review if it is against the basic structure. And the Supreme Court said by striking down the 99th Constitutional Amendment Act 2015 and said independent judiciary is also part of basic structure. He is the Keshava Nanda Bharati who has appealed the Supreme Court, and the Supreme Court came up with the basic structure doctrine on 24th April 1973. I think you may all got this key of 24 basic structure of doctrine. Thank you very much, and my special thanks to Satish Kumar Pendiala sir, Arthashastra Learning Center. Thank you very much. Jai Hind.